This is Bloomberg Law with June Grasso from Bloomberg Radio.
It is undisputed that my client has alleged an assault that is just brazenly illegal. He was at respondents' mercy in federally funded custody when he handed them a copy of a controlling precedent holding that RLUIPA protected his right to keep his hair long. They threw it away, handcuffed him to a chair, and shaved him bald.
Damon Landor is a Rastafarian who had followed the Nazarite vow, forbidding him from cutting his hair for nearly 2 decades. When Landor was transferred to a new prison in Louisiana with just weeks left on his 5-month sentence, he carried a copy of an appeals court decision that held that cutting a religious prisoner's dreadlocks violates federal law. But a prison guard threw the ruling into the trash. And despite Landor's pleas, he was handcuffed to a chair and held down while his knee-length dreadlocks were cut off. No one disputes the glaring violation of his religious rights, as Justice Amy Coney Barrett noted.
Look, the facts of this case are egregious. So if on the facts we were looking for a case in which there should be money damages, this is it.
But it's not just about the facts. It's about the law and whether Landor can sue the guards and prison officials for damages under the Religious Land Use and Institutionalized Persons Act, better known as RLUIPA. While the Supreme Court has repeatedly sided with religious litigants in recent years, a majority of the conservative justices, led by Justice Neil Gorsuch, appeared skeptical that Landor could sue individual corrections employees.
The circuits are unanimously against you and have been for many, many, many years. So saying that something awful is going to happen, it's all, whatever's happened has happened, right?
The conservatives questioned whether the prison guards had noticed that they could be found individually liable, but the liberals said the prison employees were on notice. Here are Chief Justice John Roberts and Justice Sonia Sotomayor.
If you're hired as a prison guard in Louisiana, you don't sit down, and I don't even know if Louisiana does, saying, oh, here's our agreement with the federal government, which probably goes on for I don't know how many pages. And you should look at it carefully because you're bound by it.
Generally speaking, if you're a prison official, you know you're working in a prison and you're bound by law to pay damages if you violate the law. Do you get an out because what?
My guest is John Meiser, a professor at Notre Dame Law School and director of the school's Religious Liberty Clinic. John, tell us about the law that Landor is suing under.
That act, which shorthand is called RLUIPA, was passed in 2000 in conjunction with an act that was passed a few years earlier, the Religious Freedom Restoration Act. And both of them sort of target the same goal, which is to, as a matter of federal statutory law, to restore a more robust set of protections for religious exercise, which previously had been available under the U.S. Constitution, but then following a seminal case in 1990, Employment Division versus Smith, it sort of restricted some of those rights as a matter of constitutional law, and then Congress acted to restore them as a matter of statutory law.
So explain what the problem is with him using this law.
So RLUIPA, the particular law at issue here, focuses on 2 areas of state and local government activity. One is in land use, decisions about how you can use your property. And then the one relevant here is about religious exercise in jails and prisons. And so there's no doubt that the law, RLUIPA, protects Mr. Landor's rights here. He's a state prisoner, and so therefore safeguards his right while incarcerated to exercise his religion. And the only question in this case is one of remedies. So the facts are egregious. I don't think anyone really doubts that while he was in prison, his rights were blatantly violated. He's a Rastafarian, which among other things requires him not to cut his hair. He actually had a judicial decision when he entered the prison that held the prison policy requiring, they normally require forced shaving of all the inmates' hair. He had a decision saying that couldn't be enforced against Rastafarians like him. But the guard literally threw away that decision, handcuffed him to a chair, and shaved his head anyway. So there's no doubt his rights were violated. And the question now is only what sort of remedies does RLUIPA allow for him to address that violation?
Justice Ketanji Brown Jackson read from RLUIPA and said it seems pretty clear. And 5 years ago, the Supreme Court unanimously ruled that the sister statute, the Religious Freedom Restoration Act, permits money damages against federal officials. In that case, Muslims were allowed to sue over their inclusion on the FBI's no-fly list. So why doesn't that analysis work for the law here, RLUIPA?
Yeah, so the legal question at the heart is a pretty technical one of congressional power. So what both RFRA and RLUIPA, what these laws allow is for someone who's been injured, whose rights have been violated, to file a lawsuit in federal court against those who caused the violation. The statute, the words of the law, allow you in that lawsuit to get what is all appropriate relief. So then the whole question becomes, well, what does Congress mean by appropriate relief? One thing that's undisputed is appropriate relief certainly includes judicial order that would prevent an ongoing violation of religious rights. So if the jail, so to speak, were continuing to threaten to violate Mr. Landor's rights, say they were shaving his head every week, you could get a court order telling them to stop doing that. The question, though, is, as you just touched on there, is, well, what about one-time harms? What about harms that aren't ongoing? They're over now. How do you remedy those? Does the law allow you to get, monetary damages, which would be the normal way in a lawsuit? If you've been harmed, the normal recourse in the law is you're able to get monetary damages, to get money to help in some way remedy or repair that harm. But the question here is, does RLUIPA allow that? You're right. RFRA, the sister statute, was held to allow monetary damages. And the question of, well, does RLUIPA allow the same, turns out a very particular idea of the congressional power issue here, which is Congress's use of its spending power. Does the spending clause require something more for a statute to authorize monetary damages? Does appropriate relief clearly enough convey that when a state accepts federal spending, it might open itself up or open its officers up to suits for money damages?
Did it seem pretty apparent that most of the conservative justices thought that the statute shouldn't apply here?
I don't know how clear it is, but I do think a number of justices certainly expressed skepticism about that. So there's a couple different things going on. One is, what does the statute mean? What does appropriate relief mean in context of laws like this? And so that question is, does the statute itself, is it clear enough that it allows monetary damages? And then the other is, well, okay, even if Congress did allow this, does the Constitution let Congress do that through a spending clause law like this? And several justices, I think, expressed some skepticism on one or both of those questions, but I think the skepticism all came back to a similar idea, which is spending clause legislation, right? It opens up money for state governments to take part in federal programs or to receive federal subsidies for different types of things here, jails and prisons. And the federal government can attach conditions to those. Sure, we'll help, pay for your prison facilities if you agree to comply with X, Y, and Z. And the court's concern with laws like this is that states are coming into that bargain with their eyes open, that they understand the conditions they're agreeing to. It's one of notice, one of clarity. So that's, I think, the driving concern here. I don't think it's so much about whether it would make sense to apply these substantive religious rights in prison. Everyone agrees, actually, that the prison and its officials are bound substantively to protect the rights that RLUIPA demands. But what some of the justices in the court were really struggling with was, how clear was it? Were individuals who work within those prisons really on notice that by signing up to work in the prison, they might be sued for things like this?
It seemed like a lot of the conservative justices didn't think that there was notice here. At one point, Chief Justice John Roberts said, it's a legal fiction to say that a prison guard knows what he's signing up for here. But the liberals, particularly Justice Sotomayor, said, when you sign up to work as a corrections official in a prison, doesn't that mean you're signing up to obey the law? And, the act here was so obviously brutal.
Right.
And the guard just tossed the notice he got from Landor into the trash.
I agree with that. I think Mr. Landor has a very good argument here, right? So it's of course true, as the Chief Justice pointed out, that there's something of a legal fiction here. But that's, these legal fictions run throughout the law. We're all presumed to have knowledge and be aware of the contents of criminal law. is any given person on the street actually aware of everything that's prohibited by federal or state criminal law? No, of course not, right? But ignorance of the law, even if actually true, we don't allow that ignorance of the law to be an excuse to defy it, right? And so, Justice Sotomayor's point here, which is echoed throughout the argument by Mr. Landor's counsel, is that at least in this context, where we're talking about people who sign up to work in a prison or a jail, these officers, we all the time presume they understand their obligations under federal law, under constitutional law, under state law, and they understand that if they violate those obligations, these demands that they protect our rights, that they might be sued for it. And again, I don't think there's any doubt in the case, and I think the state actually concedes that as a substantive matter, the state and its officers were bound to follow the demands of RLUIPA. So then the only question is, well, is it different? Did they need to also know, they knew they had to follow RLUIPA, they knew they could get sued under RLUIPA, they knew they could be held subject to injunctive relief under RLUIPA. Do they also need to know that they could be sued for money under RLUIPA? Well, even if that's a separate question, I agree with Mr. Landor here that it's not a very hard one because, again, as soon as you're understanding that you might be sued as an individual, the normal recourse is that if you're found to have violated the law, you might have to pay money damages.
Coming up next, where might the justices come out in the case? This is Bloomberg. The Supreme Court wrestled with whether a former Louisiana inmate can sue prison officials who cut off his dreadlocks in violation of his Rastafarian religious beliefs. The justices heard arguments in the case of Damon Landor, who wants to sue for money damages under a federal law designed to protect the religious rights of inmates. The court's 3 liberal justices seemed firmly on Landor's side, but the court's conservatives seemed skeptical. Justice Neil Gorsuch led the court's conservative bloc at oral arguments, in pressing the attorneys for Damon Landor on whether corrections employees should be individually liable for contracts made between state institutions and the federal government under a religious liberty statute.
Where did the defendant, the individual defendants, agree with the federal government to be bound? And what notice did they have? And I understand your point earlier to the Chief that they're subject to state regulations.
But liberal Justice Ketanji Brown Jackson said the statute was clear.
So I guess I'm trying to understand how Congress could have said it any clearer. I mean, to the extent that we're puzzling over whether or not there's a clear statement in the statute, it says a person may assert a violation of this chapter as a claim or defense in a judicial proceeding and obtain appropriate relief against a government. If that doesn't refer to money damages being brought by an individual for a violation of RLUIPA, what could Congress have meant by appropriate relief here?
I've been talking to John Meiser of Notre Dame Law School. Several justices pointed out that all the circuit courts and all the lower courts have ruled against Landor's position here. So why did the Supreme Court even take this case? I mean, there was no circuit split, and it doesn't seem like they took the case to reverse it.
Yeah, I think there's a couple of reasons. So one, I think many of the justices' questions overstated the level of that agreement. As I mentioned earlier, there's really 2 different legal questions in the case, which is what does the law mean? When it says appropriate relief, what is appropriate relief in context? What would that be understood? And the second thing is, even if the law does allow money damages, can Congress do that in a law like this? So circuit courts have arrived at similar conclusions, which is that RLUIPA doesn't allow damages, but they've done it through different paths. And in fact, several courts have found that, no, in fact, the law is clear here, that just like under RFRA, appropriate relief does, in fact, include damages. It's the normal expected remedy against an individual. And then, some of them have then said, but as a constitutional matter, the court can't do that. They can't, through spending legislation, bind these sort of individual third parties who didn't, agree to the funds or something like that. And then some courts have come out differently on those questions. So although it's true that damages aren't available generally in federal courts under RLUIPA, I don't think there's a lot of agreement as to why. And then more to the point, this is an area where the Supreme Court has recently providing more guidance. Right? So under RFRA, which you just mentioned, this recent case, Tanzan, courts weren't necessarily getting that right either, that RFRA allowed monetary damages. The court came in and said, no, we look at RFRA. Appropriate relief does include monetary damages against individuals as the normal recourse. That was a pretty recent decision. So now all around the country, courts are having to rethink their older precedent. Oh, is it still good law? Do I need to rethink it after Tanzan? And the court has stepped in to provide that clarity.
Justice Sotomayor and some of the other liberal justices warned that ruling against Landor would potentially put dozens of other federal statutes at risk.
Yeah, I certainly don't have a good read on just how many statutes might look like this, or, maybe relatedly, just how many other interpretations of those statutes might be implicated. Either way the court goes. But I guess I would say that, and I think all the justices acknowledge this would certainly not be the first time that the court had ruled that spending clause legislation allowed Congress to create a right of action for monetary damages against third parties or individuals. So that wouldn't be sort of groundbreaking, and the extent to which Congress can do that, or the terms through which Congress must speak. I don't think there's great clarity in the law on that now. So ruling in either way in this case is going to help provide guidance. And I'm not sure that I have a strong sense of which side is right that would be more disruptive to the law as it currently sits today.
Were you surprised at the turn that this argument took?
I don't know if I would say I'm surprised. I think initially, I think you started here actually in our conversation that there's a really strong argument, and I think good reason to believe that, well, if RFRA, through the exact same language, passed by Congress for the exact same reason to restore religious freedom, if RFRA allows monetary damages, it's very hard to understand how, its sister statute, RLUIPA, doesn't. But I think I understand the complications in the case. It's this erudite question of what Congress must do when it acts through different enumerated powers. So, RFRA is not. Spending clause legislation, RLUIPA is. They might require different things of Congress. So I do think the case is harder than it might appear at first blush, but I also would hope that the court would ultimately align the reading of the two statutes, and it would be at least a somewhat unusual result if RFRA and RLUIPA, these sister statutes passed for the same purposes, allowed different remedies. And it would leave people like Mr. Landor without any recourse to remedy what all agree was an egregious violation of his rights. And it would leave no ability to hold the individuals who literally threw away a copy of a court decision and to hold them accountable. And I think that would be regrettable, certainly.
Yeah, and one of the justices, I don't remember which justice, asked at one point what happened to the guards who did this. And the only answer was, well, the warden was transferred or left. So one wonders if there was any kind of punishment.
Right. And, here at Notre Dame, in our Religious Liberty Clinic, we filed an amicus brief in the case on behalf of a variety of religious organizations which point out the danger. If someone who's harmed can't get monetary damages, there might be very few and perhaps no options, no mechanisms available to hold these violators accountable, because if it's a one-time thing and it's over and done with and the court can't issue an order not to do it because the violation's already occurred, well, then what can you do, right? You can scold, you can reprimand the prison, and the lower court did here, so really just criticized in harsh language what had happened to Mr. Landor. But beyond that, it's a very thin mechanism to hold these folks accountable.
So, this court has, repeatedly sided with religious litigants in recent years. You could go through a lot of cases, but there's the Christian football coach who got to pray at the 50-yard line after games, the Christian web designer who was allowed to refuse to work with same-sex couples, the Texas death row inmate who got to pray with his pastor. On and on. If the court doesn't find for the inmate here, the Rastafarian, is there a danger that people will say, well, when conservative Christians come before the court, their religious rights are vindicated, but this Rastafarian inmate, his are not?
People will certainly say it, right? I think it's easy to predict that would be, one criticism of the decision if it were to go that way. I don't think it would be accurate or fair. I think the court is serious and committed to protecting religious freedom. It's a right that, as you just mentioned, in a number of areas, the court has, taken a lot of cases to ensure that it's not being diminished. around the country. I think that's true even if they were to rule against Mr. Landor in this case. And again, I think if they were to do so, which would be regrettable, I don't think that would be the right decision. But if the court were to do so, I think it would not come from any different approach based on the religious background of the plaintiff, but rather based on, some of these really difficult structural questions about congressional authority the court is grappling with. And, I would just point out that those cases and this one provide, and the court knows this, significant protections for all religions, whether any given claimant is Christian or not. And certainly not all of the plaintiffs in these prior cases have been Christian. There's one just this past term where the lead plaintiffs were Muslim families. So I don't think that would be an appropriate reading of the case now.
I mean, do you have a feel for how it's going to come out, or you don't?
No, I don't have a feel. I mean, I think this kind of goes back to what we were saying a second ago. I think it's a complicated case. I think it was obvious to me that in the argument, a lot of the justices were really struggling with how to draw these lines and these concerns over notice and keeping Congress from overstepping its enumerated powers, which itself is a rights protecting idea typically, but with the recognition that here is a seminal piece of legislation to protect religious freedom, a piece of legislation the court has repeatedly been sure to safeguard and uphold. And I think there's real tensions with how best to weigh those, competing sort of priorities of the court.
Yeah, I have to say that the case was so egregious. I mean, you have a prison guard tossing a decision in the garbage, and then they forcibly hold him down and cut off his dreadlocks. I thought they took the case to reverse the court below and allow him to sue for damages, especially considering how this court is usually solicitous of religious litigants. And the facts here, how often do you have the plaintiff showing the law to the defendant and the defendant just tossing it out? You can't make these things up. It would be...
Yeah, no, I mean, I agree. And I think at the end of the day, that the simplest reading of the case is what you're saying. This is a blatant violation of this man's rights. It doesn't seem real. They literally threw away the decision. They handcuffed him. They forcibly shaved him. And now the claim is brought under a law that's nearly identical to one that the court just said allows lawsuits for damages like this. So I agree. I think the easiest thing, simplest thing is, you take it to reverse and to make clear, yes, RLUIPA is just like RFRA. It allows these damages. And I think that's the right outcome. I do agree, though, that from the argument, it seems the court is certainly struggling with more complications than that.
Well, it was great talking to you, John. We'll see how the court comes out. That's Professor John Meiser of Notre Dame Law School. Coming up next, we'll tell you what the Trump administration told the Supreme Court about its powers to send the military into Chicago. This is Bloomberg. The Supreme Court is considering whether to let President Trump deploy the National Guard to Chicago over the strong objections of city and state officials. The case marks the first time that the Supreme Court has been drawn into Trump's effort to dispatch troops to Democratic-run cities where he claims crime is rampant and where people are protesting his immigration crackdown. President Trump's administration told the Supreme Court that he could have sent active-duty military troops to Chicago to help enforce federal immigration laws, as he urges the court to instead let him deploy the National Guard. The U.S. Solicitor General John Sauer told the court that the president has sweeping discretion to dispatch the military forces of his choosing to deal with domestic disturbances. A federal appeals court decision refused to let Trump deploy the troops, agreeing with Illinois officials that the federal government had failed to show any evidence to justify the use of troops, even giving substantial deference to Trump's claim that protests in Chicago amounted to a rebellion or invasion that necessitated the use of National Guard soldiers. Joining me is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law. So the Supreme Court has been thinking about this case since last month. And on October 29th, the justices asked whether regular forces refers to active duty troops. First of all, explain why they're asking that.
The question is, when the president can federalize the National Guard. And under the pertinent statutes, there are two situations in which the guards can be nationalized. The first is when there's an act of rebellion, and some have claimed that the government thinks that there is a rebellion going on because of the activities against the Border Patrol and ICE, but most judges dismiss that as totally far-fetched. And the second is when there is the government cannot protect or enforce federal law with regular forces. And so the question is, what does this phrase mean? And it's an ambiguous phrase, and there's been disagreement about it for a generation. And on one view, what the government says is if there is any kind of pressure on federal law enforcement, then the National Guard can be federalized. And of course, the pressure that they're referring to is the challenges to ICE and the immigration agents. On the other hand, the failure to enforce federal law with regular forces might mean the military, in which case that's a reference to the Insurrection Act, which in turn would say that the only time you can federalize the National Guard is when there is an insurrection and the military can't do the job itself. So that's an extreme, and there's a middle position in which would say that the federal government can only federalize the National Guard if general law enforcement has broken down such that federal buildings, federal ICE agents are in jeopardy of going about and doing their business. So those are the three reads of those provisions, but the idea of what regular forces mean is really key, and no one's answered. And obviously the Supreme Court is troubled about that.
Chicago is arguing that it refers to the standing military, not to immigration agents or civilians. So what does that mean?
I'm not sure that Chicago has made the more drastic argument that says that regular forces means military. I think what Chicago has argued is that the National Guard cannot be federalized because there is no rebellion and because there is no general failure of law enforcement. The federal agents go about, do their business. Federal buildings remain unscathed. So they've just said as a factual matter, the court here held, that there is no credibility to the court's position. In fact, the Chicago ducked the question of really what regular forces means. That has been raised by amicus in the Supreme Court case. And that would, the narrow reading of amicus or amici would really help Chicago. And I don't think that they have filed a supplemental briefing to join in.
So now the Solicitor General is saying that Trump could have sent active duty military troops to Chicago to help enforce federal immigration laws.
Right. And that can only be done under the Insurrection Act. And the Insurrection Act says, that there has to be an invasion. And so, unless there's some other novel reading of the Insurrection Act, regular forces cannot be used for law enforcement absent an invasion. And by no stretch of the imagination have we had an invasion. I guess President Trump might say the undocumented immigrants constitute an invasion, but I don't think that even the Supreme Court would defer to that kind of reasoning.
I mean, what does it say that the court, it's on an sort of expedited schedule, but not really expedited, and in all this time, what's happened in these cities, Chicago and Portland and L.A., at one point the Trump administration was arguing to send the troops that were supposed to be in L.A. to Portland. So I guess there isn't an emergency in L.A. anymore. I mean, does it seem inconsistent?
Yeah, no, I think that the Supreme Court is very chary of the President Trump's arguments with respect to the National Guard. I don't think they like the idea of the standing army in cities, and I think they're even skittish about the National Guard. And the statutory framework here seems very much against the Trump administration. We don't have a rebellion, we don't have an invasion, and there is very little pressure on ordinary federal law enforcement, even if we don't reach how to construe the term regular forces in the National Guard Act.
But is the Supreme Court usually hesitant, this Supreme Court, to constrain the president's authority, thinking that, there might be emergency situations where the president does have to act?
Well, there should be huge deference to the president if there is an invasion or if there is a rebellion. But if there is no colorable invasion or colorable rebellion, that puts the Supreme Court in a bind. And I think the Supreme Court members have not entered into this fray yet because they're really torn about what to do. And we're not seeing the kind of quick protection of the administration that we have in context in terms of discharging federal workers, cutting aid agreements, cutting grants, and so on and so forth.
Trump has won the last 23 cases that he took to the Supreme Court in the emergency docket.
It might be. The first one might break the streak, but I think everybody's watching the tariff case as well, another sort of bellwether where it looks like the justices may give a little pushback.
Let's turn to SNAP benefits for a moment, though this question could be over with the ending of the shutdown. But I think it's important to talk about the core question here about the SNAP benefits, where courts ordered the Trump administration to pay the benefits, and the Trump administration sent a message to states that were, stepping up and paying SNAP benefits not to do it.
I'm actually, just to shock you, I'm actually somewhat empathetic to the Trump administration on this one.
Shocking.
I mean, to dial back the clock, the district court judge within the First Circuit made an order to the Trump administration that said you either have to pay SNAP benefits November in full, or you have several days to make partial payment based upon the contingency fund. The Trump administration agreed to pay all that was in the contingency fund, which was about 3/4 of the SNAP benefits for November. But it did so in a kind of deleterious way and said we can't meet the deadline because it's too complicated to figure out how to make partial payments because of the arrangements and agreements we have with the states. And so they chose to satisfy the court order by making the partial payment from the contingency fund, as they could do, and they decided not to use discretionary funds to make up for the deficit. Now, what the court said then was you were moving too slowly. You, the government, didn't meet the deadline, and therefore, as an enforcement mechanism, we will require you to pay the entire amount. Basically, transforming discretionary funds that the Department of Agriculture had collected from tariffs into mandatory funding of one program, SNAP, as opposed to other programs such as nutrition for child and infants. This is, I think, a kind of quite an intrusion into the general discretion of how the Department of Agriculture should pay funds. And even the First Circuit seemed to think that if you had a lawsuit directed at the Department of Agriculture to require to use its discretion in this particular way by paying for the deficit in SNAP, that lawsuit would be thrown out of court as non-justiciable. That basically the decision of how to use discretionary funds is committed by law to agency discretion. So only by requiring the payment of these discretionary funds as a remedy for the government's tardy behavior in complying with the court ruling was the court able to try to close the gap and finalize the SNAP funding. So I think this is an extraordinary remedy. I think the government acted abominably here in trying to withhold monies for the SNAP program, but nonetheless, this court order seemed to overstep its bounds in requiring that the full payment be made. Obviously, this is putting pressure on Congress, and so this whole thing may become moot quickly, but time still is remaining, so we'll have to see.
Hal, what about the Trump administration telling states, you stop what you're doing to pay SNAP benefits?
I think what the administration was doing was saying, we can't guarantee you that if you pay more than if you fill the gap and pay more than the contingency funds we have released, we won't guarantee that we'll pay you back. And the federal government was right. If some states have gone and paid full November SNAP benefits. Others have paid zero. That's a state decision. And I think the federal government was just telling them, look, if you do this and you pay more than what we've already agreed to pay, you're on the hook yourself. And I think that's appropriate.
I mean, this was very important because this may be one of the reasons why the Democrats caved the SNAP benefits.
It might be. Obviously nobody wants to see people go hungry. But again, at one point, the Trump administration agreed that they would pay for November SNAP and then changed their minds. And this changing the mind, I think, infuriated the district court, which led to this extraordinary remedy that the court imposed. The Supreme Court has given an administrative stay, so we'll have to see how this all plays out.
Thanks, Hal. That's Harold Krent of the Chicago-Kent College of Law. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.